Petition stands dismissed.
52, 53 and 54.
Criminal petition stands allowed.
Obliged.
Item 53, 54 anticipatory bail applications have become infructuous in view of order passed in criminal petition 1103.
May I present? I beg to mention item number 8. Your lordship may not like to take up this matter.
Item
8.
please stand before another bench without me. On, you want a date?
Any date, my lord?
Wait, please, your lordship.
Yeah, dates will be fixed. Item number 8.
Wait, please, your lordship. Your lordship, I beg to mention for listing one FIR against injunction order, lordship.
Senior bench.
May I please, Lordship? Lordship, I beg to mention item number 17 and 39 on behalf of Mr. S. Samaria. He has some personal difficulties today, Lordship.
Item
17 and 39, Lordship. I am for the petitioner, Lord. 39.
prayer of learned counsel for the petitioner. Please the matter again on.
Both the matter, Lordship. In both the matters, interim order.
Interim orders passed earlier to next date of listing.
Highly obliged, Lordship.
May it please your lordship, with due consent from other side, I beg to mention item number 29 of today's list, your lordship. We are for the respondent, your lordship, in this case. I pray that your lordship, this matter may be taken up after 2 weeks, your lordship. Any date?
The prayer of the learned counsel for the respondent and with the consent of the petitioner. List the matter again on.
Obliged.
Hey, please, your lordship. Also, I beg to mention item number 32. The matter has become infructuous, Lordship, so it can be closed.
You are
Anar Sharma, Lordship, for the petitioner.
Anar Sharma, learned counsel for the petitioner, submits that the matter has become infructuous. Hence, dismissed as infructuous.
May it please your lordship. Your lordship, I beg to mention item number 3 due to some personal difficulty. Item number 3, your lordship, with the consent of the other side, due to some personal difficulty of S. Das, may
You are
come
for?
up after 2 weeks. I am for S. Das, your lordship.
On the prayer of learned counsel for the petitioner and with the consent of the respondent, list the matter again on.
After deeply obliged, your lordship.
May I please, your lordship? I beg to mention item number 55 of supplementary list, my lord. Matter may be fixed next week, my lord. Any date?
55.
Obliged.
May I please, your lordship? I beg to mention item number 13, lordship.
13.
13, 13.
13. Yes.
Wrongly came up for more orders, lordship. Services completed, lordship. It may be come up for admission, lordship.
And that is what we have to see during orders. If service is complete, let it come up.
It's supposed to come for admission. Wrongly listed in orders column.
Earlier order is there that service is complete.
Opposite party has already appeared. Their name has been shown in the cause list, lord.
It is submitted that the matter has been wrongly listed for orders as service is complete and matter is to be listed for admission. List the matter again on
Interim order may be continued.
admission. Interim order passed earlier to continue till the next date of listing.
Obliged, lord.
May I receive this matter? I recommend item number 2 and 34, madam. 2 and 34, madam. In both cases, madam, S.C. Sharma, madam, is in here, madam. Senior counsel.
2 and
2 and 34.
Item 2.
In fact, what has happened in item number 2, there is a the tribunal is to be formed. There is some instruction that tribunal is likely to be formed. So therefore, the matter was adjourned for some time. Some other matters are fixed on 20th of this month.
28th.
20th, 20.
No, you mentioned now item number 2 and
34 months.
34.
Both the cases, S.C. Sharma is appearing, madam. Senior counsel.
2 and 34 list the matter before another bench without me. On 20. On 20.
This is a piece of paper. Diploma. All right.
May I please, Your Lordship? This bail application, anticipatory bail application has been filed, Lordship. It was already rejected by this honorable court. That was on 4th of November. Now, two aspects of the matter, Lordship, this I have highlighted in this particular bail application. Is the delay, Lordship. This is 4/11/2025. Nothing has happened till date. And the second reason is that, Lordship, the mother of the petitioner is not keeping well. So he is in need of taking care of his mother. So because of this pending,
So nothing has happened means?
this 4/11/2025, the order has been passed, Lordship. No investigation proceeded in that way, Lordship. There is no substantial progress in the investigation, Lordship. For last 3 months, and I am ready to cooperate with the investigation in all possible forms, Lordship. My mother is also ill, Lordship. I made a specific statement, but I am not in a position to take care of my mother because of this pending case, Lordship. I will cooperate with the investigation in all possible ways, Lordship. Kindly consider the interim bail so that I can take care of my mother and I will cooperate with the investigation. I will disclose whatever is there and why the amount has been transferred and how it has been transferred. Even I have given the undertaking with regard to the fact that I am going to return the amounts. Although the fact remains that because of certain other reason I have transferred the amount. But since I have admitted the fact that I have transferred, so I cannot take that plea also, Lordship. But I am ready to return the entire amount, Lordship. Some time is also required for that. Even I have not been able to join any job also, Lordship. Because previous job I have resigned and subsequently I was intending to join some new job. Because of this pendency of this criminal matter, Lordship, I am not in a position to join.
I don't have the CD.
Some protection, interim protection, Lordship.
It was rejected earlier. How can you have interim protection now?
Short date may be given, Lordship, from this to Lordship. '27.
May please, Your Lordship.
Yes.
Also, this appeal has been filed against an order of the Commissioner for Employees Compensation. So in this case, the Commissioner has passed an award for the date of the workman for rupees 8,52,160. But what has happened in the process, Lordship? He has also imposed an interest at the rate of 8%, plus Lordship a penalty, Lordship. That penalty, Lordship, is insurance company is not liable for penalty. That is my case. Insurance company is liable for compensation plus interest, but penalty is not the liability. That has been decided by the Supreme Court in its judgments, Lordship.
This is a first appeal, isn't it?
First appeal, Lordship.
And you have formulated substantial questions of law.
Yes, Lordship.
It's required.
It's required, Lordship. It's required in the substance. It can be filed only on substantial question.
But first appeal.
It's a first
The
appeal,
section?
but as per his Lordship, this is like a second appeal in case of WC. In a regular first appeal, it's question of law and fact. Here it will be on question of law, which is substantial in nature because it will decide the dispute between the parties. Unlike other regular first appeals, WC appeals are always on substantial question of law. Section 30 of the Act, Lordship, is this law. Principal. Usual.
So how has the commissioner acted without jurisdiction?
He has imposed penalty, Lordship.
Yes, whether it is within his jurisdiction or not, where is that law?
Lordship, this particular point has been decided, Lordship, only on this particular point. This is judgment. Lordship. Insurers are, employer might be liable, but insurers are not liable, Lordship. There are 19 of the judgment, Lordship.
Heard the petitioner.
Argus Amendments.
You appear for?
Respondent number one, Lordship. A Hussain.
For the respondent number 1. The appeal is admitted. The following substantial questions of law. You will find in the synopsis itself, okay, 1 and 2. Issue notice to the remaining respondents. Petitioner to take steps by speed post with AD appellant within 3 days. This after 4 weeks on. Record is to be called for.
Record is record.
Call for the here.
There is a I for stay also.
Where is the I?
Deposit 50% of the order. I'll deposit 50% of the order amount.
Hard learned count I 2501 hard learned counsel for the petitioner and appearing for respondent number 1. The connected appeal has been admitted for hearing. In view of the same, the impugned order dated
Dated for 27/6/2024.
passed by
First, the Works and Compensation Commissioner, Bongaigaon.
page 8, okay. Passed by the commissioner. Workmen's
WC case number 9 of
Bongaigaon
27.
in WC case number 09 of 2007. Shall remain state subject to deposit of 50% of the awarded amount within a period of 7 days.
Lordship will take 4 weeks.
4 weeks.
I have to take the order and communicate with certificate.
In a period of 4 weeks from today. List again on
And then maybe allowed to do this.
Yes, sir.
Maybe reflected.
the respondent number. Only one.
One on.
The number 1 allowed to withdraw 50%.
Yes.
Of the 50%.
No, that
Whole entire amount.
that 50%. Yes.
The entire amount. Subject to submission of indemnity bond.
Yes, sir.
List again on same date. Okay.
Obliged.
It is a lordship. My lord, in this matter, the respondents appeared, my lord, and filed a reply to your application, my lord. And this honorable court has granted till eternable date interim, my lord, state the proceedings My humble submission, my lord, almost matter is finally ready for disposal, but Lord Court record in this matter has not called for. If the lordship fix the matter after 2 weeks, with the records, the entire matter may be disposed of after receival of records, my lord. Since my learned friends also appeared for the respondents, my lord, matter is almost ready for hearing.
Lordship, the lower court record is not required because the matter involved is only here is only regarding a question of law. Whether security can be adjusted towards rent and therefore that record is not required. Whatever is there in the record is more than sufficient for decision in that regard.
I leave it to your lordship. I'm ready, my lord. Otherwise, if record is not necessary, I'm also ready today, my lord. But evidence of the learned court trial could discuss so far as all this, though my learned friend has annexed these documents, but regarding the records is very necessary for final disposal. Other, if lordship deem fit the record not necessary, my lord, I'm ready, my lord.
Evidences are there. We have annexed.
Then it should be, we should go for a hearing then. Admission disposal may not be
I
possible.
have come from all the way from Silchar to do the hearing.
Where did you come?
My learned friend's convenient when the final date may be fixed for final disposal, my lord. I'll leave it to him since he's come from Silchar, my lord. He must get opportunity for
If
fixing.
these are simple, otherwise if it is some simple matter we could have, but apparently this will take some time.
Yes, my lord. It will
Take a long list.
Lordship, in my humble opinion, it will not take, it will take 10 minutes.
Really?
5 minutes either side.
Yes, all right, go on.
Yes, my lord.
He has also determined your time as 5 minutes. So stick to 5 minutes.
Well, as well as but it will take some time, my lord. Or anyway, my lord. I could reply to this. For 3. Asiatas. My lord, kindly. Petitioner before your lordship, my lord, is the plaintiff, tenant, my lord. And lordship will find plaint at page 16, annexure 1. Briefing before taking to the milord, in my plain only one paragraph I will read, milord. That is paragraph number 2. Please sit. Page 17, paragraph 3, milord. That well, I'm sorry, milord. Paragraph 1 and 3 I will read, milord. Paragraph 1 is very vital. Page 16. That the plaintiff is a monthly tenant under defendant in respect of the shop room described in the schedule below, that is with effect from 1/4/2005 on execution of tenancy agreement of same date for a period of 3 years, fixing monthly rent of rupees 3,400, evidencing the term and the conditions thereon, including the payment of 50,000 as interest-free security and advance rent of 50,000 with provision of adjustment thereof at the rate of 500 per month from the amount monthly rent. The defendant thereafter collected rent in respect of the scheduled room from the plaintiff from his business premises, and therefore the time-to-time tenancy agreement in respect of the scheduled room were executed by and between the plaintiff and the defendant with enhancement of monthly rent, and further payment of security deposit, and such tenancy agreement were dated 3/4/8 and 4/4/2011. That by the said tenancy agreement, that is dated 4/4/2011, the period of tenancy granted by the defendant was for a period of 3 years with effect from 4/4/11, and monthly rent was fixed 4,497, and milord, the 50,000 as interest-free security remained with the defendant, and further the 14,000 was paid by the plaintiff to the defendant as advance rent with provisions of adjustment thereof, and with the monthly rent of 500 per month. Such advance rent has already been adjusted, and the security deposit 50,000 as mentioned above still remain with the defendant. This is our main crux here, milord. Next, milord. Then, my lord, one paragraph, paragraph 6 of the complaint. Because of the long-standing relationship in between the plaintiff and the defendant, the plaintiff believed the defendant in good faith and made attempt to contact the defendant for the payment of the monthly rent of the said month. An execution of fresh tenancy agreement ultimately talked with the defendant over telephone 8814, but surprisingly, the defendant changed his stand and expressed that he will not accept any rent from the plaintiff, and further he will not grant any further tenancy in favor of the plaintiff in respect of the scheduled room. Rather, in a very angry mood, demanded that the plaintiff is to come to the defendant and to hand over the key of the iron rolling shutter of the scheduled room. Then, such circumstances, plaintiff become compelled to rent for all months with effect from the September 14 to January 15 so and advance rent so per month in view of the fact that always defendant declined to accept such rent from the plaintiff. As such, defendant always refused to accept the same in various rent deposit cases court at Landed Court of Munship 1 Silchar. Now, my lord, WS filed by the respondent at page 36. And lordship, they have denied all the grounds taken in the plaint, and in page 43, the real fact of the suit as per their statement at page 43, paragraph 22 onwards. I read the 43 minute. The defendant is the absolute owner of the suit premises described in the schedule below. The plaintiff is a businessman and approached the defendant for the grant of tenancy of the premises described in the schedule below for period 3 years, with effect from 4th day of April 2011 in consideration of payment of monthly rent of the rate of rupees 4,497. The defendant granted the tenancy in favor of the plaintiff with respect to the premises described in the schedule below for a period of 3 years with effect from 4th April 11 by execution of bilateral deed of tenancy agreement dated 4th day of April 2011, executed by and between the plaintiff and the defendant. The tenancy was granted by the defendant to the plaintiff in consideration of payment of monthly rent, only payable by the plaintiff to the defendant with effect, within the 15th day of the following English calendar month. And on receipt of the monthly rent, the defendant is to execute receipt without which no acknowledgement to be recognized. A sum of rupees 50,000 was paid by the plaintiff to the defendant as interest-free security deposit. The plaintiff further paid an amount of 14,000 as advance to be adjusted with the monthly rent of the rate of 500 per month, and rest of the monthly rent to be paid by the plaintiff to the defendant. The plaintiff agreed to pay the electric bills of the suit premises along with 1/3 of municipal taxes. It was agreed in the aforesaid tenancy agreement that the expiry of renewal of tenancy is taken from defendant. The plaintiff shall deliver khas possession of the suit premises to the defendant immediately after the termination of tenancy period. In accordance with the terms of the tenancy agreement, the defendant allowed the plaintiff to enjoy the tenancy over the suit premises over the entire period on receipt of the monthly rent at the adjustment of rupees so each month till the entire amount of rupees so adjusted. After adjustment, the plaintiff has been paying the rent at the rate of rupees so. In the above manner, the plaintiff paid rent lastly on 2/4/2014 for the month of March 2014. The tenancy expired on 31st day of 2014 and has not been renewed thereafter. But defendant, even at expiry of the tenancy period, did not deliver his possession of the suit premises to the defendant, nor has the plaintiff paid any rent for the period after March 2014. This is very important, my lord, kindly mark it. Hence, the plaintiff is a defaulter. In respect of the payment of monthly rent in respect of the suit premises, and therefore an evictable tenant in view of the provisions of the Assam Urban Renewal Act 2019-72. Moreover, the suit premises is required by the defendant for his own requirements. This is, my lord. Now, my lord, most important, my lord, most vital exhibit is Exhibit 14. This is Annexure 4. This is the tenancy agreement at page 52, Annexure 4. Here, most important clause is clause number 5 and 9, but I will read the clause, my lord. Here, lordship will find the Abhijit Roy is the respondent, owner, my lord, and Dhanraj Surana. This is the present petitioners, my lord. Lordship will find Now the agreement witness and parties agrees as under. I'm skipping all these things, my lord.
Clause, you are reading clause?
Page 5, my lord, clause 1 onwards, my lord. Clause 5 and 9, kindly mark it, my lord. Important clauses 5 and 9. But I will read, my lord. This agreement is very essential to decide this matter, my lord.
Page?
Page 52 is the agreement, my lord, but I will read from 53 onwards.
Yes.
Yes, my lord. That the landlord hereby grants tenancy in favor of the tenant with effects with respect to the said premises from the 4th day of April 11 for a period of 3 years. That the tenancy shall be according to English calendar month. That a tenant shall pay monthly rent of the 4,497 only to the landlord for the said premises. That the rent for each month as aforesaid shall be paid by the tenant with the 15th day of the following English calendar month to the landlord or his authorized agent, who shall grant receipt thereof to the tenant. No place of payment of rent except the written receipt of the landlord or his agent shall be ascertained. Now, my lord, 5. That a second party, that is the owner, my lord, sorry, the petitioner, my lord, that the second party shall pay a sum of rupees 50,000 only to the first party as interest-free security, which shall be refunded by the first party to the second party after the expiry of tenancy, my lord. This is important. Moreover, the second party shall pay a sum of rupees 14,000 only as advance, which shall be deducted as 500 only per month from the monthly rent of so and so. Only and after termination of the tenancy, any amount stand as balance of advance to be adjusted shall be repaid by the first party to the second party, that is the tenant. This is my clause number 5, my lord. Now, my lord, kindly, my lord, come to clause number 9 directly. I am concerned clause number 5 and 9 only, my lord. That after the expiry of the period of state settlement of, if no fresh settlement, that is renewal of tenancy, is taken from the landlord, the tenant shall deliver his first possession of the rental house to the landlord immediately after the said period. Now, my lord, and in case the tenant desires to continue as tenant, the rent for such 3 years tenancy period will be enhanced at the rate of 15% from the monthly rent of earlier 3 years period. Other terms and conditions of the tenancy remaining same, and after expiry of the 3 years, fresh agreement is to be made between the party. Here, my lord, I am concerned here, my lord, paragraph 5 and 9. Paragraph 5, it is there, my lord, already present petitioner has deposited 50,000 rupees security to them. In some place they have denied, but in their evidence, my lord, they have said, yes, that 50,000 rupees still with me. The landlords, my lord. And, my lord, what is then after termination of tenancy period condition agreement, my lord, the landlord is to repay the same amount to the tenant, but same has not been paid to me, my lord. And so far as clause number 19 concerned, my lord, there is further, my lord, in written statement, he has not said clearly, my lord, but in the agreement it is that if after termination of the tenancy agreement, if the tenant wishes to desire to continue as tenant, my lord, then he's ready to pay enhanced rate of 15% monthly rent, my lord. This amount, and even landlord is also ready for go for the fresh agreement, my lord. Now, my lord, the impugned judgment, my lord, the appellate court findings I will take first, my lord, at page 122.
Yes.
Yes, my lord. I'm coming, my lord. With the lordship due permission, my lord, Shall I read the on the relevant discussion made by the appellate court for the
Yes, yes.
for the whole judgment, my lord? Whole judgment, may I read, my lord?
Discussion, read.
Yes,
Judgment part I have read already.
yes, my lord. Yes, my lord.
Which is the issue involved in the present?
Yes, my lord. Page 129. Issues on suits, paragraph 9. Suit on suit. Very next page, in the 130, my lord. Issues on counterclaim. This is a counterclaim made by the defendants, my lord. Now, my lord, page 132. Discussion, decision, and reason thereof. Para 14. Now let me discuss the grounds taken in the memorandum of appeal along with the relevant issues decided by the learned trial court in the impugned judgment for the sake of convenience. I have considered the oral and the documentary evidence as well as the written arguments of the respective side and also perused the trial court case record. Now, on going to the issues decided by the learned trial court, it appears that issue number 1 and 2, whether there is any cause of action for the suit and whether the suit is maintainable in its present form and manner, respectively, were decided together by the learned trial court, and the learned trial court had held that the suit has got no cause of action as the fact of defaulter of the plaintiff appellant has become apparent and the plaintiff appellant himself was held accountable for being a defaulter in payment of the rent. The further, the learned trial court also held that suit is not maintainable within the meaning of section 5(4) of the Rent Control Act. Though the learned trial court held that the suit has no cause of action when the plaintiff appellant himself has held accountable for being a defaulter in payment of rent, as was apparent as per the decisions already made by the learned trial court in issue number 5. But on meticulous reading of the pleadings of both the sides, it is seen that the plaintiff's assertion of the facts and defendant's traversal definitely gives rise to a cause of action in respect of the lease of 1994 6 SEC 322. This is Dhanraj Surana versus Abhijit Roy. So. The Honorable Apex Court held that the cause of action, it is to be meant every fact which, if traversed, it would be the necessary for the plaintiff to prove in order to support his right to the judgment of the court. Hence, there is a cause of action.
I'm not concerned with that here.
Yes, I'm not concerned. So, my lord, therefore, my lord, I'll have to take a lordship directly to the main discussion with it. My lord, 149.
Yes.
Page 20, para 29. During the cross-examination of PW1, has admitted that he started to deposit rent in the court from the month of September 2014. He has not made payment of monthly rent of the month of April, May, June, July, August 2014, as defendant refused to accept the same. When he went to deposit the rent of the May, and the defendant did not accept the rent, but he did not deposit the same before the court immediately and waited for the next month. He also admitted that Exhibit 14 does not provide any scope to deposit rent in advance, and none of his rent deposit cases are prior to September 2014. The PW1 has also admitted that he has not submitted any FIR regarding the Alice incident of Durga Puja Swencho. PW1 has further admitted that he has not submitted any document regarding 144 CRPC proceeding. The defendant respondent DW1 has deposed in his evidence on affidavit that tenancy period expired on 31st day of March 2014 and thereafter the same was not renewed. But the plaintiff appellant, even after expiry of the tenancy period, did not deliver the possession of the suit premises to him, nor has the plaintiff appellant paid any rent for the period of March 14. Hence, the plaintiff is a defaulter in respect of the payment of monthly rent in respect of the suit premises and therefore an evictable tenant in view of the provisions of Act. Moreover, the suit premises is required by him for his own requirement. DW1 has also deposed that he has several times requested the plaintiff to deliver first possession of the suit premises, but the plaintiff did not do so, and hence the defendant respondent caused service of legal notice on 17/11/14 upon the plaintiff appellant after 8 months of expiry of the tenancy agreement, my lord. Draw his advocate demanding the plaintiff to vacate the suit premises within 15 days of receipt of the notice. But the plaintiff appellant did not comply with the notice, rather filed a case by Swencho. The plaintiff is a defaulter in respect of the payment of rent for the suit premises described in the schedule of the plaint, and the tenancy period expired long by 31st March 14. Moreover, the suit premises is required by the defendant for his own requirement, but the plaintiff is required to be evicted from the suit premises with his bag and baggage. Now, paragraph 13 is the evidence of DW1, my lord. That during cross-examination, the DW1 admitted that before the expiry of the validity period of Exhibit 14, this is tenancy agreement, he did not issue any notice to the plaintiff demanding him to vacate the suit room. He did not inform the plaintiff in writing before the expiry of validity period of Exhibit 14 that he will not grant renewal of any tenancy in respect of suit room. He also admitted that Exhibit 14 in clause number 9, it has been mentioned that in case the tenant desires to continue as tenant on expiry of period of settlement covered by Exhibit 14, then the rent for such 3 years tenancy period will be enhanced at the rate of 15% from the monthly rent of earlier 3 years period. Although he received notices issued by the court in connection with the rent deposit cases, he did not file any written objection against any rent deposit cases filed by the plaintiff in respect of the suit room. Exhibit 11 is a certified copy of the rent deposit challan, miscase number Swencho, in the court of Learned Munchif 1, through the challan rent of the monthly April to July 14. That means April to July 14, petitioner has paid rent before the Learned Trial Court below, my lord. Even no objection has been filed by the landlord. Consequently, rent for the suit premises was deposited in the court by the plaintiff as the rent were not accepted by him through the different rent control cases. Now, in my view, in view of the analysis of the evidence on record, as aforesaid, it appears that the tenancy agreement, that is the Exhibit 14, expires after the stipulated period of 3 years, that is 3rd of April 2014, and as the same was never renewed by the defendant, being the landlord of the suit premises, the terms and conditions of Exhibit 14 ceases to remain applicable after 3rd April of 2014. In such circumstances, Section 5 of the Rent Control Act comes into play. Now, according to the Act, a tenant does not become a defaulter merely because he failed to pay the rent. However, a tenant can be treated as a defaulter if the conditions laid down in Clause E of Section 5(1) of the Act of Section 4 of the Section 5 are satisfied, which are mentioned below. The tenant must fail to pay the rent lawfully due, as opposed to the rent payable under the contract of the tenant. Number 2, the tenant must fail to pay the rent within the fortnight of its falling due. On refusal of the landlord, the tenant is given the right to deposit the rent in the court, and if he deposits the rent in the court in accordance with the provisions of the subsection 4 of the Section 5 of the Act, the tenant shall not be treated as a defaulter. Now, in the light of the aforesaid provisions of law, when this court look into the case record of the trial court, it is revealed that after expiry of the period of tenancy agreement, that is 4th April 2011, that on 3rd of April 14, the plaintiff appellant continued to occupy the rented suit premises on 2/4/14. The defendant respondent came to his said premises for the last time and collected rent for the month of March 2014 from him against the issuance of the receipt of this as his will. As per the trial court record, the Exhibit 15 is the last rent receipt issued by the defendant respondent in favor of the plaintiff appellant. The plaintiff appellant contacted the defendant respondent for receiving rent of the subsequent month, but the same did not yield any purpose. As such, having no alternative, the plaintiff appellant started depositing rent in the court from September 14 onwards. Now, the tenancy agreement 4th April 2011, having been already expired on 3rd April 2014, is beyond any dispute. But even thereafter, the plaintiff had been occupying the suit premises. As per the Exhibit 14, the rent fell due within the 15th of every English month, as agreed upon both the parties, the said tenancy agreement. It is apparent that 3rd of April 14, no tenancy agreement between the parties was in force, neither the parties entered into a new tenancy agreement. However, as per the Exhibit 14, it was agreed upon by the parties that if the tenant desires to continue as tenant on expiry of period of settlement, then the rent of such 3 years tenancy period will be enhanced at the rate of 15% from the monthly rent of earlier 3 years period. The plaintiff started to deposit rent in the court from the month of September 14 and did not make any payment of monthly rent for the month of April, May, June, July, August 14 is clearly admitted by the plaintiff appellant in his cross-examination. Absolutely wrongly recorded. Already, my lord, in paragraph 31, this recorded. I have deposited from the April to July, my lord, in the court, but here, Learned Trial Court has recorded this wrongly recorded. Now, my lord, ultimate findings, Lordship will find at page 162, paragraph 46.
No, it is recorded even earlier that you started depositing from September.
Yeah.
After April, you did not deposit. And in your plaint also, that is the story that the landlord said he will accept it later on.
Yes.
So he used to collect. He did not come. You called him up. He said he'll take it together in September.
Yes.
And then he did not take it. So you started depositing from September.
Well, no objection if he felt
Yes.
yes,
But now you are saying you are depositing from April itself.
That
goes against your pleadings.
Yes, Exhibit 1, these are all the salons, my lord. He had recorded, my lord, Exhibit 1 salons, my lord, and deposited petitioner. Paragraph 46, my lord. Now, upon perusal of the Exhibit A of the defendant respondent, that is 17/11/14, it transpired that said legal notice was issued belatedly after expiry of validity of Exhibit 14 agreement by the defendant respondent being a landlord upon the plaintiff appeal. However, in view of the foregoing discussion, in light of the materials on record as well as the reported decision, this court is of the opinion that issuing notice belatedly by the defendant respondent being a landlord is an omission, and same does not release the plaintiff appellant from his primary duty as a tenant from the paying rent and to the safeguard himself from the being termed as a defaulter under the Rent Control Act. Page 169, para 70, order, final order, my lord. Resultantly, the appeal filed by the appellant plaintiff is devoid of any merit, and as such, the instant appeal is then dismissed on contest without cost, and impugned judgment and decree passed by the learned trial court does not record any interference of this appellate court, and according to the said impugned judgment and decree is hereby affirmed and upheld. Now, my lord.
So basically, you have been held as a defaulter.
Defaulter, my lord.
So only way to get out of is to show that you are not a defaulter.
My lord, only 3 grounds I have taken in the instant matter. Lordship, kindly have a look on page number 12. Then 3 grounds I have taken, my lord. And in this ground, my lord, I will show you, Lordship, one citation of our this Honorable High Courts, my lord. At page 10, ground number 1, 2, and 3 only, my lord. My first ground is very important in this matter. On this ground relying, my lord, the instant revision petition has been filed. For the learned courts below, the completely overlooked the tenancy agreement 4/4/2011, Exhibit 14 and Annexure 4, as well as the evidence on record, and arrive at the impugned findings that the plaintiff petitioner is a defaulter in respect of payment of rent. Whereas the Exhibit 14 and Annexure 4 clearly states that after expiry of the tenancy, the defendant respondent must return the interest-free security deposit of 50,000, which was admittedly not returned by the defendant respondent. And as such, the plaintiff petitioner cannot be considered as defaulter as per the Urban Area Rent Control Act 1972. In this first ground, my lord, I will let come, my lord. One citation I will rely, my lord. Number 2, my lord. The further the tenancy agreement 4/4/11, Exhibit 14, also states clearly at clause number 9 that in case the tenant desires to continue as tenant, then the rent for such 3 years tenancy period will be enhanced at the rate of 15% from the monthly rent of earlier 3 years period. Other terms and conditions of the tenancy remaining same, and after expiry of 3 years, fresh agreement is to be made between the parties. And therefore, it was an agreement made with full power vested on the tenant about continuation of the said tenancy. And since the petitioner plaintiff wanted to continue with such tenancy with the enhanced rate, and also offered rent to the defendant respondent as the landlord, the defendant respondent also admittedly refused to accept the same. Therefore, petitioner plaintiff cannot be termed as defaulter under the Rent Control Act. Finally, Miller, ground number 3. For the defendant respondent for the first time served a legal notice on 7/11/14, Annexure Exhibit A, asking the plaintiff petitioner to vacate his premises on the ground of defaulter and bona fide requirement. Prior to issuance of said notice on 17/11/14, the petitioner plaintiff had already started depositing rent before the court, and therefore the petitioner plaintiff cannot be termed as defaulter prior to issuance of such notice. And both the courts below completely overlook all such vital aspects. As such, the impugned findings are liable to be set aside and paused. And most importantly, in the Exhibit 14 below, the clause 5 and clause 9 has not elaborately discussed, my lord, and In this regard, my lord, the DW1 in its evidence, he has enclosed his reply. I like to read DW1's cross, my lord. That is 201. In its reply, my lord. Examination Chief 201 and cross will start from 204.
Yes.
Yes, my lord. My house is at Central Road, Silchar. If I proceed towards the Parabtala via Central Road, my house will be on the right side. There is a lane by the right side from the Central Road, and in corner of my house is situated. The first room towards Central Road in the ground floor is being used by me and for my own business. My residence is on the first and higher floors. The suite room is in the second room in the ground floor facing the lane name Sensu. Exhibit 12, 13, 14 are related the tenancy of the plaintiff under me and respect of the second room. Exhibit 14 covers the period of 3 years from 4/4/2011. Those tenancy agreements, Exhibit 12, 13, 14 were prepared by my consent before the expiry of his consent, Exhibit 14, kindly note it. And before the expiry of the validity period of Exhibit 14, I did not issue any notice to the plaintiff demanding him to vacate the suite room. I did not inform the plaintiff in writing before the expiry of the validity period of Exhibit 14 that I will not grant renewal any tenancy in respect of suite room. In Exhibit 14 in clause number 9, it has been mentioned that in case the tenant desires to continue as tenant on the expiry period of settlement covered by Exhibit 14, then rent for such 3 years tenancy period will be enhanced 15% from the monthly rent of the earlier 3 years period. Although I received notices issued by the court in connection with the rent deposit cases, I did not file any written objection against any rent deposit cases filed by the plaintiff in respect of the suite room. Exhibit 11 is the certified copy of the rent deposit challan, case number so in the before the Court of Learned Munsif 1. Those such challan ran for the month of April to July 14 were deposited by the plaintiff by lot. Plaintiff. Consequently, rent for the suit premises was deposited in the court by the plaintiff as the rent were not accepted by me, though different rent control cases. The plaintiff earlier and presently also resides in Janigan Silchar town. His house is at distance at about 20 kilometers from my house. Exhibit 15, the rent receipt was issued by me in favor of the plaintiff. And my lord, kindly read the bottom, very bottom line. That the plaintiff was an old tenant of mine and for considerable period for which I had a good relation with the plaintiff. Earlier, the plaintiff also used to believe me. It is not a fact that the plaintiff believed me, my expression over phone, and I also received the rent for the April-September 14 attempt. In my examination in chief, at page number 2, I have mentioned that I received a rupees 50,000 as interest-free security deposit and also rupees 14,000 advance from the plaintiff. That much only. Now, my lord, he has admitted here, my lord, on his due consent, my lord, Exhibit 14 was made, my lord, and even he has not issued notice regarding.
What was the monthly rent?
Monthly
Agreed
rent, initially monthly rent, my lord. I'm sorry, my lord. My lord, 4,497 in my agreement, paragraph 3, page 53. And after expiry, this is 15% will enhance, my lord. I'm ready and I'm deposited.
With 15% enhancement, what is the amount?
If 50% would be, my lord. That's it. 97. 15% plus 8. So that is 5,000. এরকম 60 প্লাস করে 5,171.
Right. 517.
71.
So according to him, you defaulted for how many months? According to him,
From April to
April, May, June, July,
July.
August. No,
August.
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 5 months.
5 months.
So what is the total amount of default? 25,855.
Yes, and 50,000 already
50,000 is already there
there, my lord,
as security.
as security.
Security means to be adjusted against non-payment of rent.
Yes.
And another 15,000 in advance.
Advance. 14,000, my lord. Minus. In this regard, my lord, one decision delivered by this honorable court at 2010 3 GLT 490, my lord, like to place before this court, my lord. Kindly. Paragraph 18, 19, 20, and 22. Very small paragraph, my lord. My lord Justice video.
Para?
Para 18, 19, 20, 20, and 22. Para 18, my lord. In addition to the aforesaid evidence indicate the defendants were indeed did not default in payment of rent, Exhibit Co is another document which also comes to the rescue of the tenant petitioner. This is a document executed on 79 by two co-owners of the suit premises, namely so-and-so, acknowledging receipt of 70,000 from the father of the defendants, with a stipulated that said amount would be refunded with interest of rupees so-and-so per month by the persons who would be holding the ownership of the godown property to get it vacated. Both the learned courts below have rejected the theory of adjustment of the 70,000 against monthly rent at the time of evicting the tenants on the ground that the documents refer to a godown, whereas the suit premises is a shop. I find from the record, it is the initial stage of the trial itself, the defendant has specifically taken the plea of advancing of rupees 7,000 to the previous landlords as security, with the condition that a said amount would be refunded at the time of termination of the tenancy in the additional written statement. Despite the specific averments in the written statement, no subsequent pleading was filed by the plaintiff, strangely except the challenging the document Co. In legal grounds, the sole plaintiff witness did not dispute about the fact of payment of 70,000, nor challenge the authenticity of this document. Only during the oral argument, the document was interpreted so as to relate to go down and not to the shop. I make it clear that it is not the case of the plaintiff, respondent, or defendant have been let out any other premises in addition to the suit premises to use as godown on rent basis to take in view of 70,000 must have been paid against the godown and not against the suit premises in paragraph 22. In the case before me, there was no statutory transfer of the leased property. Only by way of a mutual settlement, the suit premise was given to one branch of the joint family members. Be that as it may, one of the plaintiff was a signatory of the Exhibit Co, and as such, his liability to redeem the advance of 7,000 continued with the provision of Section 109. Hence, I told that until and unless the said amount 70,000 is paid to the petitioner defendant, neither the defendants can be said to be defaulter, nor the tenants can be terminated. That must be got. So, my lord, admittedly, my lord, go to learned trial
You
court.
just read which paragraph?
22.
22.
Final paragraph 22. Lordship, due permission, may I read again, my lord? In the case before me, there was no statutory transfer of the leased property. Only by way of mutual settlement, the suit premise was given to one branch of the joint family members. Be that as it may, one of the plaintiff was the signatory of the Exhibit Co, and as such is liable to redeem the advance of rupees 70,000 continued with the provision of Section 109 Transfer of Property Act. Hence, I told that until and unless the said amount of 70,000 is paid to the petitioner defendant, neither the defendants can be said to be defaulter, nor the tenancy can be determined. I'm on this point only, my lord. That amount is still with the landlord, my lord, until clearance of these things, and even I have paid before the learned trial court below. Those 5 months period, my lord, the learned court below has not emphasized on this point, my lord, and clause number 5 and 9, there is categorically stated certain grounds, my lord. Even in the cross, landlord has admitted, my lord, on his consent, this agreement was made, my lord. So, my humble submission, my lord, since my amount was admittedly with the landlord, my lord, the learned trial court, without discussing all this evidence as well as the Exhibit 14 tenancy agreement, and held me a defaulter, my lord. So, I'm.
Is there any discussion in the appellate judgment regarding this 50,000?
No, my lord. Only fact recorded, but no discussion, my lord. Kindly, my lord. No discussion, my lord. So far as 50,000 deposit is concerned, my lord. Only facts, my lord. Page 120, paragraph 2, plaintiff case, it is recorded only, my lord.
Yes.
So my humble submission, my lord, both the learned court will arrive the findings to be interfered with, and my lord.
All right. Yes.
Bless.
5 minutes.
The division has been preferred with 3 grounds as narrated by my learned friend. Ground number 1, basically reading it, whereas the said Exhibit 14, Annexure 4 clearly states that after expiry of the tenancy, the defendant respondent must return the interest-free security deposit of rupees 50,000, which was admittedly not returned by the defendant respondent. As such, the plaintiff petitioner cannot be considered as defaulter as per the Assam Urban Areas Rent Control Act 1970. The other 2 grounds are more or less similar. So, Lordship, the 2 consecutive courts have found the petitioner here as defaulter within the meaning of Section 5 of the Assam Urban Areas Rent Control Act. And the question boils down to whether the security deposit amount which is live can be adjusted towards the monthly rent. And can that rescue the tenant from being a defaulter? The answer within the provisions of Section 5 of the Assam Temporarily Settled Areas Tenancy Act makes it absolutely clear, Your Honor. Apart from other, C provides 5C, Lordship, the Assam Urban Areas Rent Control Act, Section 5C, where the house is bona fide required by the landlord either for the purposes of repairs or rebuilding, or his own occupation, or for the occupation of any person for whose benefit the house is held, or where the landlord can show any other cause which may be deemed satisfactory by the court. Then Lordship, E, where the tenant has not paid the rent lawfully due from him in respect of the house within a fortnight of its falling due. And that how the tenant is to make payment of the rent has been narrated in subsection 4, where the landlord refuses to accept the lawful rent offered by his tenant, the tenant may within a fortnight of its becoming due deposit in court the amount of such rent together with process fees for service of notice upon the landlord, and on receiving such deposit, the court shall cause a notice of the receipt of such deposit to be served on the landlord, and the amount of the deposit may thereafter be withdrawn by the landlord on application made by him to the court in that behalf. A tenant who has made such deposit shall be shall not be treated as a defaulter under clause E of proviso to subsection 1 of this section. Unless this is complied with, Lordship, the tenant will become defaulted. The admitted position is that for those 5 months within the fortnight, that is within 15 days, he did not tender the rent in the court by means of the rent deposit cases. He began depositing the rent together for the months of 4 or 5 months at a time in the
From
month of
September.
September, which is not provided in the Assam Urban Areas Rent Control Act. The Lordship, I am placing two judgments of this honorable court. One reported in 1984, 1 GLR 297, and the other in that ratio descendi has been decided, Lordship. Person who does not pay rent properly and regularly shall be held as defaulter. Then the other judgment I am relying on 1988 1 GLR 121, and this similar contention has been similar things have been held by the Honorable High Court. Lordship, so the ultimate analysis boils down to whether that 50,000 can be adjusted towards the rent. And in this regard, Your Honor, from the plaintiff as well as the agreement.
This deposit only from September, is it an admitted position?
Yes, this is an admitted position. This is the in cross-examination itself. This is the cross-examination of PW1 that has been made abundantly clear. Lordship, on perusal of the plaint, original plaint, will find that and the rent agreement, which has been relied upon by my learned friend in paragraph 5, that is the page 54, we can read it again. The second party shall pay a sum of rupees 50,000 only to the first party as interest-free security deposit. That is interest-free security deposit which shall be refunded by the first party to the second party after the expiry of tenancy. Moreover, the second party shall pay a sum of rupees 14,000 only as advance which shall be deducted at the rate of rupees 5,000 only, and after termination of the tenancy amount, any amount stand as balance of advance to be adjusted. Lordship, it is to be read in entirety. A document is to be read in entirety and not in isolation. That is coming after only as advance which shall be deducted from rupees 500 only per month from the monthly rent of rupees 4,497. So that amount of 500 is to be deducted from the amount of 40,000 which was paid as advance rent, not to be adjusted towards the amount of 50,000. So the learned trial court and the appellate court did not commit any error in that regard, Your Honor. Neither the jurisdictional nor the appreciation of evidence. And they rightly arrived at the decision that the petitioner is a defaulter within the meaning of Section 5 of the Assam Urban Areas Rent Control Act. The judgment.
So in substance, your submission is that since the agreement itself provides how that security deposit is to be dealt with, it cannot be adjusted against rent.
Adjusted with the rupees. Then this submission that has been made with the help of the other judgment, they say that is with regard to the tenancy that is created under the Transfer of Property Act, not under the Assam Urban Areas Rent Control Act. Yes, Transfer of Property Act is the general law regarding transfer of properties. When there is any special act, the special act will definitely prevail over the general provisions of the Transfer of Property Act. So that judgment relied upon by my learned friend is not applicable to this case at all. I have placed two judgments of the Honorable High Court, Your Honor, how a person is to be treated as a defaulter and how he is to be held as a defaulter. What is the procedure regarding that? That has been dealt with in these two judgments elaborately. So my humble submission is that Lordship, the petitioner is an out and out defaulter, and the law applicable is that as pronounced by this Honorable High Court, once a defaulter, always a defaulter.
Yes.
Once a defaulter, always a defaulter, and therefore this revision falls absolutely your lordship and liable to be dismissed.
All right.
Lord,
Yes, CAB.
Obliged.
Mayor. This application, order dated 29/4/2025 has been challenged, which is at page 101. Lord, this petitioner, as plaintiff, filed suit, my lord, praying for declaration of right title interest and confirmation of possession. The other side, my lord, is filed WS and also counterclaim, my lord. In the counterclaim, pray for right title interest, my lord, and recovery of possession. My lord, trial court, my lord, aid interim injunction granted, which is page 36. Thereafter, my lord, while the injunction was heard at length, my lord, this injunction was granted in my favor. And my lord, the appellate court, my lord, reversed the order. And strange enough, my lord, this injunction petition, my lord, a recovery of possession order in favor of the, my lord, defendant.
Respondent has appeared. Yes.
Yes, my lord. If you go into the operative person of paragraph 35 and 36, which is a page, my lord, 131, 132, that in injunction petition, recovery of possession granted, which is, my lord, without jurisdiction. My lord, on the provision of, my lord, Order 39, Rule 1 and 10, there is no such provision that the injunction petition, my lord, possession can be.
In this case,
recovered.
already record was called for. Lordship may fix the matter for hearing any day.
Yes, heard learned counsel for the appellant and learned counsel. Sole respondent. PCRS called for has been received. Matter is ready for hearing, hence the appeal is admitted. Please the matter for hearing on.
Lovely.
My lord, in this appeal, the plaintiff respondent here filed a suit for declaration of right title interest, and the suit was dismissed by the trial court holding that the suit number one suit is barred by res judicata, and petitioner failed to prove the original deed of sale deed, my lord, and other grounds. They filed an appeal. The order of the trial court has been reversed. Against that I have come. Now, first thing is, my lord, this appeal, they filed a suit for back for non-genital necessary parties. And even appeal also, it is on non-genital necessary parties. Now, in Lordship, kindly see, I have the judgment of the Honorable Trial Court, my lord, first. Page 47.
Yes.
Page 47.
You have given many grounds, but which is the actual substantial question of law involved here?
I'm sorry, my lord. The one substantial question, most important substantial question of law, whether the suit is barred by res judicata or not, that point has not been taken. This is the main ground. And other grounds, my lord, a lot of kindly see that ground. Ground 1, 2, 3, all are important because, my lord, on the basis of Jawamandi, they cannot claim any title, my lord. And this trial court held, Jawamandi, their name entered wrongly, my lord, from whose the plaintiff passes the land. He has no sale deed, nothing, he is no owner, but his name has been mutated. From he is the plaintiff passes the land, and those persons are not, the witnesses are not been examined. And from the London trial court has found that the Jawamandi name, intent of the name is different, and the land passes by the different, my lord. This is specifically held. If a lordship can listen best quotation for a moment. Hello, space 51. Issue number 2. Paragraph 19. Page the test number so where judgment is already delivered on so and in that particular suit, an issue was decided that the defendant Abdul, here's the plaintiff, has inherited the share of Abdul Samad. As such, the point that plaintiff has inherited more or less 12 bigger so by right of inheritance. After the death of his father, the deceased unmarried brother, late Samad Ali, has already decided in title suit number so hence this issue is hit by principle of res judicata. Now, learned appellate court has reversed it. He held that it is a point of res judicata will not applicable. Now, let's say issue number 4, paragraph 3. Relevant paragraph 26, page 53. Now, according to now, regarding Jawamandi Govi, my lord. Issue number 5, 6, 7, and 8, paragraph 27. Directly, my lord, see page 28, paragraph 28. Plaintiffs claim that he purchased 2 kata Swensu lands appertaining to Dagnova Swensu, according to Dagnova Swensu of Nurul Islam, by the Swensu. The plaintiff further stated that in the plaint that he lost the original sale deed, and as such certified copy was brought on to record. Mention was made the vendor's father's name was wrongly noted as Haji Ismail instead of late Ibrahim Ali. And the name of plaintiff was written as Ahmed Ali, my lord. Ahmed Ali in that sale deed. Now, paragraph 29. The plaintiff, in absence of original sale deed, brought to record the certificate copy, which is exhibit 5, perused the same and found that various vendor's name is Nurul Amin, son of Swensu, Haji Ismail, and purchaser's name is Ahmed Ali. To prove the document, they call the volume record of sub-register so in official witness who only proved the contents of the sale deed, but the execution of sale deed is not proved, and there is nothing on record which could prove that due to mistake the vendor's father name and purchaser's name were wrongly inserted. No correction of the said deed was made subsequently. Moreover, none of the PWs has deposed that they knew about the instant sale deed except the plaintiff himself. Thus, under such circumstances, the sale deed is sufficiently proved. Paragraph 30 also clearly held. But learned appellate court bill has been reversed those findings, my lord, and come to know that since their name is appearing in the government copy, they have the right to interest. That is why this substantial question of law, my lord, the law secondly see whether the judgment degree learned appellate could suffers from perversity. Perversity is that he did not elaborated the evidence on the court properly, my lord. Now, learned appellate could irradiate law and holding the Jawandi is proof of title. It cannot be, my lord. Whether Jawandi can confer any right title of interest, my lord? This is the point. Number 4, for the learned court will give its finding that the execution of sale deed are not proved. The learned law appellate court below, the appellate without discussing the execution of the sale deed. Now, logically say, in the meantime, during pendency of the, I filed one affidavit. Affidavit, one of the legal heirs, he filed a suit after that. But he was not party in that suit matter. That suit is going on. I given the answer. I filed affidavit, my lord. That copy of the plaint, page 87 of the memo of appeal, my lord.
Right, at this point, we are only required to consider whether any substantial question of law has arisen.
Yes.
Yes, respondent.
My lord, here in this case, my lord, the first point which he has been raised regarding res judicata, my lord, it is not a substantial question of law. It is a mixed fact, actually. After the learned trial court held that it is a res judicata, lower appellate court specifically held that, kindly see that part, my lord. At page 74. Yes, page 74. Lordship, page 74. It is, thus it is considering the foregoing, not
Paragraph
73, paragraph 12. Paragraph 12, page 73. Doctrine of res judicata is a universal application. Whether or not matter was directly and substantially in issue in former suit has to be determined by referring to the plain, written statement, issue and judgment. It was the duty of the defendant to call for produce the relevant record in order to show that this present suit cannot be entertained being barred under provision of so and so. But I am on convey that the defendants have not been able to bring in the relevant record in order to hold that this suit is indeed barred by res judicata. That apart, the question whether the suit is barred by principle of res judicata is a question of fact and not question of law. Moreover, the title suit number so and so is still pending disposal, which was remanded by the first appellate court after setting aside the judgment and decree dated so and so. Thus, it cannot be said that the said suit or issue which the matter has been directly and substantially in issue in the former suit has been heard and finally decided. So it is a question of fact.
Yes.
It is not a substantial question of law. And regarding this second point, which has been raised, that mutational entry does not confer any title. Lower appellate court also said that no, it is not conferred any title. But since this, I am the plaintiff, I filed the suit. One part is for as a partition, I got by way of inheritance, another part by way of purchase. So far the part by way of inheritance part, question of title deed does not come. This point has been elaborately discussed by the lower appellate court. That since one part is, and apart from that, kindly see what is the suit about. Kindly see the suit about at page title suit, copy of the title suit, my lord, at page starts from page 15
prayer part, page 18. Page 18.
Just a moment.
Declare the right title interest of the plaintiff over suit schedule described A1, B1 and C1 to the plaintiff with confirmation of possessions thereon. So here in this case, we are in possession over the suit land. So we sought for confirmation of possession. Next prayer to declare that plaintiff is entitled to revenue partition. That means there was an inherited property, ancestral property. We sought for on the basis of two prayer. One is confirmation of possession, another is for partition, revenue partition only. So far revenue partition is concerned, already it has been executed and revenue partition has been held. And nothing survives in this case.
Now, what about the other part?
Other part,
You said that there is two aspects. One is
one aspect is declaration of right title interest, and another consequential relief is the revenue partition. That has already been executed, revenue partition. And suppose today this suit is dismissed also. Suppose they have not filed any counterclaim that this land is belong to them, this land fall under their share. There is nothing, no counterclaim, nothing.
Philosopically, my friend is page 18, 4 philosopically prayer. My friend did not read.
That is
In case revenue authority is unable to put the plaintiff in physical possession of the suit land after partition, the learned court may please to allow khas possession. What is the meaning, my lord?
that part,
My lord.
part is
Oh,
innocuous prayer, my lord. That is innocuous prayer. When I have specifically pleaded that I am in possession, we have confirmation of possession has been sought for and for revenue partition. So subsequent disposition part may not come in this case because I have not pleaded also that I have been dispossessed during the pendency of this case, all these things. Suppose this type of prayer has been made when there was a question that during pendency disposes. Suppose he has dispossessed me. Then that type of prayer has been.
no, all these suppositions and propositions as what will happen or what will not, that are may be the subject matter of another proceeding. But
Yes.
at present, we are concerned with what substantial question of law has arisen.
Yes. So here in this case, no substantial question of law involved in this case that I have stated. Regarding title, the learned Appellate Court has rightly held that I have a title, and so far res judicata part is concerned, it is rightly held that there is no res judicata involved in this case.
Philosophically, page 51. Clearly held, page 51, paragraph 19. The trial court.
Yes, 51.
Page 51, paragraph 19. That trial court record has been perused by the trial court. And ultimately that suit was disposed of. Philosophically, 19. Perused yes number so where judgment is already delivered on defendant Abdul Hamid has inherited a share of Abdul Hamid. As such, the point that plaintiff has inherited more or so less so.
You want to press res judicata?
Yes.
That is always a question of fact.
Yes. But it is a question of law, my lord. Because it is a section 11 is strictly barred.
No, whether it is barred by res judicata or not, that is a matter of inquiry.
Yes. Then you
will have to show that judgment and by which the present suit is barred. That is a question of law, whether any such judgment exists. Affecting section 11.
Judgment is there. Several
That is a question of fact.
I will place that judgment.
No, I am not talking about your Supreme Court or anything. I am saying if there is any judgment in respect of this case, which bars the next case,
yes,
that you have to place to show that it is res judicata.
We already placed that judgment.
So that is a question of fact.
That judgment already placed. And
it is a question of fact. If it has been ignored, then it is it may be the matter of a civil revision, not a question of second appeal.
Then while the law see the other points.
If the court has ignored material evidence and acted with material irregularity, that may be the subject matter of a civil revision.
Then 53, my lord, logically see.
Unless a substantial question of law is made out, how can it be?
That suppose logically is correct, I have no objection. Now logically see issue number 5, 6, 7, and 8. conjointly decided that
Page?
issue, my lord, page 53. The passage Swensu appertaining Dagnova Swensu, Dagnova Swensu from Nurul Islam, shall the Swensu
Where are you reading page? 53 para?
28. Para 28. my lord. And para 26 also regarding resident now according to rule 99, Muslim Principle of Mohammedan law, whole Bada Swensu. Now Abdul Hamid died, Bachelor Swensu. Abdul he is being only brother and not upon the concerning brothers. This point was decided in the same line of this number Swensu. Decided. Now paragraph 28. The relevant is paragraph 29. The plaintiff, in absence of original said deed, brought to record the certificate copy which exhibited at Exhibit 5, perused the same and found that vendor's name is Nurul Amin. Philosophically, he is Nurul Amin and he passes for Nazrul Islam, son of Haji Ismail. And purchaser's name is Ahmed Ali, not Hamid Ali, my lord. Hamid Ali is the plaintiff, he passes, not Hamid Ali, Ahmed Ali. To prove the document, they call the volume record of Forum Sub-Register Office. PW6 is the official witness who only proved the contents of the sale deed, but the execution of sale deed is not proved, and there is nothing on record which could prove that due to mistake, the vendor's father's name and purchaser's name were wrongly inserted. No correction of the said deed was made subsequently. Moreover, none of the PWs had deposed that they knew about the instance held except from the plaintiff himself. Thus, under such circumstances, sale deed Swensu is not sufficiently proved. Now, listen further. The plaintiff has claimed that the plaintiff has purchased 3 cutters of land Swensu from Askil Ilahi and others by register number Swensu. Proved the same, he exhibited the original sale deed, Exhibit 6. Now, a sale deed is to be proved as per section 67 of the Indian Evidence
Yes,
Act.
we have read that. After that, what happened? These are,
30.
of course, questions of fact.
30, my lord. None of the executant brought to record.
So this is in your favor?
Yes.
Yes, then.
Yes, but those findings has been reversed by the learned appellate court. Learned appellate court completely ignored about the finding of the learned trial court. So that is the purpose it is there. That is why it is.
Where is the discussion on that point in the appellate order?
Yes.
Yes, respondent, no discussion on that?
Yes, discussion. They discussed but negative and held
Maybe
that
negative.
it is not correct. Illustration page 68
Not discussing and
Page
negating are two
78.
different things.
Yes. Page 78.
Yes.
Page?
Page 78. The defendant never challenged entries of so and so as regard. Lordship got it. 18D.
In D. Okay.
Second paragraph, I think. Page number 70.
Yes.
Defendant have been unable to prove the contrary as far as purchase of the suit land is concerned. The appellant plaintiff has been able to prove the same, exhibiting the sale deed marked as exhibit so and so through PW so and so. The learned trial court, while discussing the issue number, erred in law, in fact, and decided that said issue against the plaintiff as such decision so and so. It was duly proved regarding purchase part. And another part is the ancestral part. So this is the finding of fact. Regarding possession also it was discussed.
Page 76 from my learned friend may read the whole, not close-wise. Paragraph 17A, you also can see, page 76. It is start from paragraph 78.
Yes.
The plaintiff apartment as regard the purchase of land from Nurul Islam and Akil Ilahi. Others were not specifically denied by the defendant in their written statement. Rather, the defendant took a plea that the sale deed are false. Although a defense forgery has been made out in the written statement, yet a meticulous scrutiny of contention contained in the written statement does not disclose such particulars of forgery as is required under Swensu. Hence, the such plea fails. The plaintiff, after purchase of the said land, mutated his name in relevant records of rights. Learned trial court held that observing that no order or any sale deed has been produced to assess the saleable right of Asik Ali so and so so and so. Important, my lord. Land appellate courts of Khali, they are not the owner, they are not the record holder, my lord. How can their name enter in? I am not in agreement with the landed court below in this regard. Exhibit so and so Jawandi clearly shows the note near that Asik Ilahi Olil Ullah so and so name mutated by parts of purchase and positions. Illospecally came back to the findings of the landed trial court. He held that no, there is no sale deed, nothing. No purchase has been deed has been proved. The said entries remain unchallenged and attain finality. Consequently, it can be decided that Asikula Swensu has saleable right. So the record may come, my lord. Illustrative limited possibly admitted record is to be examined. Those exhibited document is to be examined, my lord. Now, as regard issue number 7 is concerned, it is based from example that the pertains to land Swensu, Quandan Swensu, exhibit Swensu concern the land Swensu of the land Patal number Swensu, Jawamdi Swensu reveals that certain Patatas and certain lands to certain purchasers. Note is physically mentioned, my lord. Certain purchasers, certain owners, my lord. It cannot. Illospecally see, sale deed executed by one Nurul Islam, purchased by one Ahmed Ali. Now they place that judgment showing that they purchased. His name is Ahmed Ali, not Ahmed Ali, my lord. His father name is Ismail Hussain. And completely different. Learned trial court has rightly decided the issue, my lord. And the learned appellate court, while revising the that findings, did not clearly scrutinize that evidence part of the record. So, my lord, Joseph call for the records, original records. And we are in position. Now let's say another other parts are there. Mandal learned appellate court will has not at all considered the case of the appellant here.
All matters of appreciation of evidence.
Evidence
But
as well as law.
Even if there is an erroneous finding, we can't interfere.
That is why perversity. That is why perversity will come, my lord. Inverse means perversity.
Perversity is also a count for civil revision.
Perversity is
Not
the
of second appeal.
perversity is the one of substantial question of law. I will place the judgment, my lord. Perversity is the one of substantial question of law. It is not that the appellate court will ignore the evidence of he is to deliver the judgment as per order put on rule 32, my lord. He should discuss all the relevant facts, relevant evidence, my lord.
What I am seeing there is
Yes.
discussing those evidence. Result may not be in your favor.
And it is not a concurrent finding, my lord. It is a reverse.
How can you say that it is not discussed?
And it is a order of reversal. So it is to be examined, my lord, because perversity is there, and section 66 of the Evidence Act also not considered. If lordship give me sometime, I will place the judgment. The perversity is the one of substantial question of law. And if concurrent finding is there, that of course I cannot claim, my lord, as a matter of right.
Even if there is concurrent finding, provided it gives rise to a
this court can
substantial
interfere.
question of law, we can interfere.
Yes, this court can interfere.
And conversely, even if it is a judgment of reversal, if there is no substantial question of law, will not interfere.
Yes. So matter will be examined, my lord, thorough examination is necessary. Lordship give some time.
In order to examine, we have to formulate the substantial question of law. That is what we are trying to find out.
They will then fix another date. I will place the judgment. They get the perversity, my lord. Next week, and I will place judgment. Several judgments are there in this point.
I will learned counsel at length list the matter again on
next week.
So in order to enable learned counsel for the appellant to place certain authorities. satisfy the court that a substantial question of law is involved in the present RSA.
Hello.
May it please your lordship, CRPIO 90/22, as per Lojima report, service has been completed for admission hearing.
Third learned counsel for the petition office note 18/6/25 Lawazima Court by order dated 17/6/25 has deemed service to be complete in respect of numbers 1A, 1B and 1C. Is the admission. Here is required. Sir. Yes. Call for the TCR. This is against what? What is the appellate judgment where?
Yes,
May I please your lordship, as per earlier order lordship, a fresh notice was issued upon the respondent number 2 lordship. Step was taken on 3/9/2025 lordship. So kindly matter may be placed on Lojima court to verify the status of the service report lord.
Taken steps or not?
Lordship 3/9/2025, we already taken steps lordship upon the respondent number 2 lordship.
For the petitioner, it is steps were taken by registered post with AD on, when did you take?
03/09/2025.
Place the matter before the Lawazima court for verification regarding service. List again on.
Much obliged. Also, this is section 24 application.
Yeah. In 42.
I'm appearing for the respondent, Lordship. I appeared, Lordship, I could not receive the copy, Lordship. They allow me 2 weeks time to file my objection, Lordship, with the direction to furnish a copy of the petition, Lordship.
Learned counsel for the petitioner and respondent. It is submitted that behalf of respondent that yet to receive a copy of the petition to furnish the same. Learned counsel for the respondent in the course of the day. Is the matter again also, and so in the meantime, respondent may file objection.
23 months. Grateful.
As per office note dated 18/6/2025, the service is completed to the sole respondent.
Third learned counsel for the petitioner. It appears from office note dated 18/6/25 that service is complete in respect of the sole respondent. However, none appears. List the matter for admission on
The interim order operating statement.
interim order passed earlier to continue till
Obligors.
May I please your lordship, as per the office note, respondent number 8 notice could not be served as the respondent was not found at the given address. 3 weeks time may be granted to collect new address and serve fresh notice.
learned counsel for the petitioner prays for 3 weeks time to collect the present address of the respondents who are yet to be served. Is the matter again on
Next.
Please, your lordship. Lordship, respondent have filed their affidavit. We have to file affidavit in opposition, but the petitioner is suffering from cancer and her treatment is still going on. So we need some time for file our affidavit.
this has been going on like this for quite some time.
Lordship, sir, treatment is going on. Is
Just a transfer petition.
lordship.
There was an order for you to file an affidavit stating whether you were
We'll file
income.
affidavit. We need some time.
You are representing the husband.
Yes, Lordship. Lordship, we have.
Earlier one case was transferred to Dibrugarh.
Lordship, now the status I do, I'm not aware because Lordship, I have lost contact with the respondent Lordship. I tried to contact him yesterday, but his number is not reachable. So I also need some time, Lordship.
On the prayer of learned counsel for both sides, list the matter again on date.
Lordship, there is an interim order.
Interim order passed earlier to continue.
Obliged.
May it please your lordship. Your lordship service is complete in this matter. And there is an interim order. I pray for extension. And the matter can be fixed for admission.
Learned counsel for the petitioner. It appears that service is complete. You are appearing for?
Respond the respondent.
Learned counsel enters appearance for all the respondents. What about TCR? Required?
Let it come admission for the admission first, my lord, then.
All right. Hence list the matter for admission.
Your lordship, there is an interim order.
Interim order
pray for-
passed earlier to continue.
Much obliged.
The next date of listing.
May it please your lordship. Your lordship, in this matter, we'll have to file substitution petition. So I,
Who expired?
respondent
It is submitted on behalf of the petitioner that respondent number
1.4 and 1.12 has
have
expired.
expired and hence substitution petition is required to be submitted. Hence list the matter again on. So in the meantime,
Your lordship, there is
necessary
an
petitions may be filed.
interim order. I pray
Interim
for
order passed earlier to continue till the next.
much obliged.
Well, please, your lordship. Lord, service is it's complete in my lord. Earlier, my lord, the
Learned
respondent for
counsel
tweet
for
was
the
not complete.
petitioner as per office note. Learned advocates have entered appearance for respondents number 2 by filing wakalatnama. What about a 1?
1 to 1 4 already appeared, my lord. It is
And number 1 is already represented.
reflected in order dated 7/4/25, my lord.
Hence, is the matter for admission. Interim order, if any, shall continue till the next date of listing.
Deeply obliged.
Probably the wrong record has come. Because it is civil revision petition number 73/2024. Civil revision IO has come, probably record.
Yes. Jurebala Rai.
This is Sofika Bewa. The cause list, it is CRP 73. And the record which is brought before your lordship is CRP IO.
Wrong record has been placed as against the present item. Registry to place the matter along with the correct records. On list again on.
Okay.
In this, a survey has been completed, Lord. My lord, I am appearing for the husband, my lord, respondent. My lord, 2 weeks' time may kindly be granted. We will file an affidavit in opposition, my lord. The transfer petition.
All right. Heard learned counsel for the petitioner and learned counsel for the respondent. Raise for 2 weeks' time to file objection. And is the matter again on.
Interim may be continued. Obliged, Lordship.
May I please your lordship, as per the office note dated 16/7/2025, respondent two appeared by filing Okalatma answer notice regard to respondent number one, address expired. We will take step for substitution of
As
number
per
one.
office note. Who has expired? Number two
Yes, lordship.
or one?
Respondent number one.
And number one has expired as per note on, or as per postal note. Full stop. List the matter again on so and so. In the meantime, petitioner may file substitution petition.
Obliged.
Yeah, please. So as for the office note at 11/7/25, the respondent was supposed to file an affidavit.
Due to ill health of the respondent number one, I could not file it. Pray for 2 weeks time. I'll definitely file it.
Lordship, in the meanwhile, Lordship, the TCA may be called for Lordship.
Learned counsel for the petition, learned counsel for the respondent prays for further 2 weeks time to file counter affidavit. The matter again on so and so. In the meantime, call for the here interim order passed earlier stands extended till the next date of listing.
Lordship, can it be on 16th? 16th March. I love Lordship.
May I please go ahead? As per the office note dated answer notice has returned to respondent number two insufficient. We will take fresh steps regards to respondent number one.
As per office note dated 29/7/25, this has been returned unserved with comment insufficient address .rts. Quote. Further ID card or unserved notice respect of respondent numbers 2 and 3 have also not been returned. Petitioner to take fresh steps for ascertaining proper and complete address.
If there is an interim order, item number 24, there is also interim order.
24.
Yes. Obliged.
None appears. List again on.
I am appearing on behalf of respondent. So respondent has no objection, is Lordship has allowed this application.
This is the matter before another bench without me. So
Also, please.
Your Lordship, the petitioner and respondent are husband and wife, and the respondent deserted the petitioner since 4/5/2013, and their marriage was taken place on 29th January 2013. And then 4/5/2013, the respondent deserted the petitioner. And their child was born on 6/11/2014. Respondent never paid any maintenance to the child or the mother or nothing else. And by which ultimately bound the petitioner to file FC criminal case for 17/2021.
Where is the case pending now?
Pardon, my lord?
Where is the case pending?
Present case is arose out from the that is title suit divorce 35/2025 filed by the respondent side, my lord. And the petitioner is extremely in poverty and cannot move to the Sribhumi district.
Firstly, answer my question. Where is the case pending?
The earlier case is pending in Silchar, my lord. Revision is in Silchar 17/2021.
You are seeking transfer of which case?
That is title suit divorce 35/2025.
Pending before additional district judge?
Sribhumi.
Sribhumi. Sribhumi, Silchar, same.
Sribhumi is Karimganj. That is Karimganj district.
See what you have written in your cause title. Sribhumito Family Court, Silchar, Kachar.
Family court is in Silchar.
Silchar.
Sribhumi is another district.
And that is Karimganj, my lord.
Earlier it was Karimganj.
So is it pending before family court or district additional district judge? Then see your cause title.
No, sorry, I'm sorry, actually, I have just received the copy. The matter is pending before the district judge and they are willing to transfer it from Sribhumi district judge to Silchar family court.
You have filed an objection.
Just now I have received the PDF
Heard learned.
in PDF form, your lordship.
No, because the way the learned counsel for the petitioner has started, I thought we were going in for a hearing. Yes, heard learned counsel for the petitioner, learned counsel for the respondent submits that she is yet to receive a copy of the petition. Can be furnished to her in the course of the day. List the matter again for admission on.
We will come along from Silchar. Is it okay for you?
Actually, it is in 25th March or I have the case.
Obliged, your lordship.
Yes. Lordship, one maintenance case is already pending before the learned JMFC 1 Sribhumi. So, Lordship, therefore, the petitioner decided to transfer the divorce case at Sribhumi for better adjudication, Lordship.
You have got the objection.
We have no objection, my lord.
You have no objection.
I am also from Sribhumi only.
Heard learned counsel for the petitioner and the sole respondent. This is an application under section 24 CPC, praying for transfer of FC civil case number 506/2023 from the family court Kachar, Silchar to the court of the learned district judge Sribhumi. Learned counsel for the opposite party submits that the opposite party respondent has no objection to such transfer. Hence, the prayer is allowed. The FC civil case number 506/2023 pending in the court, pending in the family court Kachar, Silchar stands transferred to the court of the learned district judge Sribhumi. Records be transmitted accordingly. Petition stands disposed of.
Yes, my lord.
My lord, notice has not been served, my lord. I may be allowed to take fresh steps.
Was the last order. You were supposed to take fresh steps.
Item 33. The first time we have taken steps. My lord.
Was directed way back in August 25, petitioner shall take steps for service. Heard learned counsel for the petitioner as per office note dated 17/11/25 is issued to respondent has been returned unserved with postal comment no such person unquote. Petitioner is directed to take fresh steps for ascertaining proper address of the sole respondent. Is the matter again on
But interim prayer, may continue, my lord. My lord, interim order passed. Hi, lord.
Service is completed, my lord.
We have entered appearance.
My lord, there is an interim order.
Admission.
Third learned counsel for the petitioner, Mr. D. Ullah, learned counsel has entered appearance for the sole respondent. Please the matter. Again on admission. Interim order passed earlier to continue till the next date of listing.
High level.
May it please your lordship. Lordship, there's an error on my part, your lordship. What has happened? The cost title, your lordship, of the CRP, then it shows that the case is filed by Sri Bijosh Kumar, not the petitioner. Again, the respondent is Lakhi Rani Das. Whereas, your lordship, what had happened in the year 2017, the suit was filed by, in the trial court, the suit was filed by Lakhi Rani Das, but in the year 2018, after she expired, the cost title had been amended. But because of an inadvertent mistake on my part, it's reflecting the name of Lakhi Rani Das. Your lordship, if may kindly turn to page number 12, it will be very clear.
So you have to correct it now.
Well, yes, your lordship, I seek permission to correct the cost title and file
Learned
the
counsel for the petitioner submits that the name of the respondent has been inadvertently shown as Srimati Lakhi Rani Das, alias Bijoy Lakhi Das, who has already expired, and seeks time to file appropriate application for correction of the cost title. Hence, is the matter again on.
if you obliged. Lordship, item number 37, it shows insufficient address. Lordship, I need some more time to bring the alternate or correct address. If
Learned counsel for the petitioner, as per postal note dated 26/11/25, unserved notice to the respondent has been returned with postal comment, quote, insufficient address, .rts, unquote. Petitioner to obtain correct address of the petitioner of the respondent and take steps accordingly. Is the matter again on.
Keep your list.
May it please your lordship, on behalf of my senior advocate B.K. Das, I'm appealing for the petitioner, your lordship. Your lordship, kindly pursue the office note dated 17/11/2025. The service is not complete, your lordship. We pray for some time to take a step. The opposite party is not yet complete, your lordship.
Third learned counsel for the petitioner. Sir, so and so, you are Mr. Gogoi?
Here Gogoi Lordship.
Here Gogoi
2, 3 and 4 Lordship.
represents respondents number 2, 3 and 4. As per office note dated 17/11/25. Service on respondents number 6, 7 and 8 are complete. But none appears. ID cards in respect of respondents 5, 9 and 10 have been received back with the signatures of other persons. Within bracket, not the respondents. And neither ID card nor unserved notice has returned. Respect of respondents number 11 and 12. And process server's report has not been received till petitioner to take fresh steps on service of notice. The unserved respondents 5, 9, 10, 11 and 12. I speed post with AD. Is taken on.
Obliged.
I appeared, my lord, for the fixed for admission.
Learned counsel appearing for the petitioner. Mr. appears for the sole respondent, hence leaves the matter for admission on.
He may be continued.
Obliged.
Asil negi?
If any. None appears. List again on.
On behalf of respondent, my lord. I mean, fix for admission in the meantime, want to file our objection. my lord.
We have learned counsel for the petitioner.
Respondent,
Learned counsel has entered appearance for the all respondents.
all the respondents.
All respondents. For all the respondents. Hence leaves the matter for admission.
Lordship, TCR can It was called for, but it was not received till today.
And copy of TCR not received. Reminder is the matter for admission.
Interim order is there.
And so interim order passed earlier to continue till the next date of listing. In the meantime, respondent may file objection.
Much obliged, Your Lordship.
I've entered appearance for the sole respondent.
Third learned counsel for the petitioner. Learned counsel, Mr.
R. Ghosh.
There's appearance for the sole respondent. Is the matter for admission on
Your Lordship, there's an interim.
passed earlier to continue to the next date of record has been called for.
No, Your Lordship. Your Lordship, record may not be required because there's only one witness who has been examined so far. Obliged.
Obliged.
And this was. Lordship, today is fixed for consideration of the interim prayer. However, service is not yet completed. Therefore, a date may be fixed after 2 weeks.
Third learned counsel for the petitioner. Service is not yet complete. Is the matter again on so and so. Also issue reminder for scanned copy of the TCR.
That's okay.
Yes.
Your Honor, I am representing on behalf.
Learned counsel for the petitioner. ID card or unserved notice in respect of the respondent has not been received back as per office note dated 14/11/25. Await service list again on.
Obliged. Please, Your Lordship. It's an IA for substitution of the legal heirs of the respondent number 3, Lordship. But there is a little bit correction, Lordship. Okay, kindly see the page number 5, Lordship. Serial number 3, Lordship. Ranju Majumdar and serial number 4, Sonali Majumdar. They're written as daughter of late Dibakar Majumdar. But Lordship, now I come to know that they are the sister-in-law of the Dibakar Majumdar. So I may be allowed to correct the same, Lordship.
Sister-in-law.
Sister-in-law of the respondent number 3.
They are also necessary parties.
Yes, Lordship.
But it is submitted on behalf of the petitioner that the names of that the respondents number 3 and 4 are the sisters-in-law of the deceased Dibakar Majumdar. That they have been shown as daughters of late Dibakar Majumdar in the cause title, which were to be corrected. There is allowed file amended title. Dibakar Majumdar is a lady.
Oh, Lordship.
Wife of Bhola Majumdar.
Lordship, actually written as Srimati Ranju Majumdar, daughter of Dibakar Majumdar, wife of Bhola Majumdar.
Yes.
Sir, may be corrected all the three IA Lordship. Obliged.
Hey, please, your lordship. I am appearing for respondent number 1458 to 58.
Who is left?
First case, there is a delay condonation application that they filed substitution statement and delay condonation. I am for the respondent number 1, 4, and 58 to 58. Respondents.
Learned counsel for the petitioner. Sir, so and so and appears for respondents number
1, 4, 5A to 5H. 5 also expired and they are substituted.
So one is done. One and
4,
4
then 5A to 5H.
were yet to be substituted.
They filed for appellant number 1 to be substituted. I'm appearing for respondent number 1, 4, and 5A.
5 is alive.
No, 5 is already expired, so they are substituted by 5A to 5H.
Already substituted.
Earlier case, in earlier.
But this is it's shown is only as 5
They
in the cost title.
did not strike out at that one.
It is seen that in the cost title, the name of deceased this deceased Madai Sarkar is shown as respondent number 5, whereas his legal heirs have already been substituted as respondents 5A to 5H. 5H. Cost title be corrected accordingly. Have it service on the remaining unserved respondents.
Let's say 5A, they have said wife of late Madai Sarkar. Still 5 is there.
List again on.
Next case also similar, let's say. 48.
Same order.
Obliged, Lordship.
Item 49, Lordship. I am appearing for the appellant. Senior Advocate Mr. for the respondent, Lordship. Second item has been RSA filed by Mr. of the same judgment, Lordship. Common judgment, both the appeals are pending.
What to do?
Maybe there is no other matter. I would have informed. If possible, next week, Lordship, 2000. And in fact, the item number 50 is 2013 matter. Appellant sought for partition of his inherited property and some of the schedules were given, but recovery was not given by both the courts. some of the schedules were not given. So present regular second appeal by the plaintiff. Item number 50 is by the defendant for decreeing of two schedules in favor of the plaintiff. Lordship.
Let what question of law has arisen?
Lordship, in this case, question of law is that the learned first appellate court committed error in not declaring the title of the plaintiff over schedule Gha and Cho. Gha and Dityo Cho, Lordship. Appellant will be at liberty to urge any other substance that may arise at the time of hearing. On the ground of non-gender issue, Lordship was dismissed. Recovery was not granted as co-pattadars were not made party in the suit by the plaintiff, Lordship. Confirmation of possession over two schedules were given. Half of the share as claimed by the plaintiffs were given.
All right, let's have it some other time then.
Next week.
Learned. Mrs. R. Chaudhary appears for the appellant.
In item number 49.
Number 49, huh? However, none appears for the respondent. Is the matter on 16 March.
Next week, if possible.
It will not be possible. I'll be half the week. I'll not be there. So
Then after 23rd, Lordship. 31st March, Lordship.
first.
Obliged, Lordship.
Same order ulta for the respondent appears for